The first was called community property. Community property. Community property developed on what's called a continent. If you actually look at a map of Europe, our friends are from Europe, right? If you look at a map of Europe, there's England and everything else, basically, right? It's a very Anglo-centric perspective, but that's sort of how people divide it, right? You have England and all the associated English countries, right? And then you have, France and Spain and Holland and Denmark, some of the other countries in the continent, right? On the continent, particularly Spain and France, a system developed called community property. Okay, community property. Okay, they merge into a partnership. The same way that business people can come together from a corporation, right? They merge into an entity, right? It's not husband and wife; it's now like couple. And whatever property comes into this partnership will be deemed owned by both of them. Whatever property comes into this partnership will be deemed owned by both of them. It's known as community property, as the name suggests, right? It's known as community property. And in theory, at least, they're supposed to divide and share the assets equally. It didn't actually work like that. That's sort of the theoretical approach of how it developed. Okay, that is the community property system developed in Spain and France and other countries. Then there's the system that's called the English system, or more commonly called common law system. The English system and the common law. What makes this label complicated is when people hear common law, they think, oh, there's a common law and a modern rule, right? That's how you always hear it. There's the common law rule and the modern rule. Get that out of your head. That's not how this label works. To this day, states follow a common law model of property, marital property. And you ready for this? There are some modern approaches to common law, and you're going to hate me. There's common law approaches to the common law property. You see what I just did, right? Common law refers to the system developed in England. Both in the common law umbrella, there's modern trends and older trends. And this just messes with your mind because you think common law means the old one, right? No. New York, for example, is a common law property state. New Jersey is a common law property state. But they follow modern trends within common law property. Everyone get that point? You have to be very careful and use the phrase common law. All right. We'll study common law first because, frankly, it's a little bit easier. The community property is harder, and we'll do that one second. But we'll start with common law. Again, so when I say common law, I'm referring to the English system. I'm not saying the old way. All right. Under the common law system, in theory at least, the husband and the wife have separate property. The ownership is given to the spouse who acquires the property. A person's property is separate from a spouse's property. Now, again, this might seem, oh, wow, that's great, Josh, promotes equality, whatever, right? As a practical matter, the husband owns all the assets because he earned the income. Right, so even though in theory, each one has separate property, the husband still more or less controlled all of it. All right. Today, as a practical matter, there are not terribly big differences in reality between the two, right? Even common law states have adopted rules that make it somewhat similar to community property. So whether you live in one state or the other, it's not going to make a terrible difference, but there are differences you'll have to learn. right? And again, those differences matter upon death and divorce. Are you with me so far? Today, most states, like 40 to 42 states, I think, have a common law system. About 8 states keep a community property system. And these are primarily states that were in the South and in the West influenced by French and Spanish law. Arizona, California, Idaho, not sure about Idaho, but anyway, Louisiana, Nevada, New Mexico, Washington, which again, I don't really know, and Texas, which is one that probably most of you care about. Texas is a community property state. And for any of you who will either get married or do domestic law, that's significant because couples who are getting married in Texas need to be aware of the rules of what they can and can't do. And couples getting divorced in Texas need to be aware of the rules of what they will and will not get. And couples, or I guess married individuals who plan to die in Texas, which is a lot of you, right, need to be aware of how you can dispose of your assets and what you can and cannot keep from your spouse. I know this sounds awful, but what you'll find, at least in this class, is that couples don't always get along the best. And often there are disagreements over how to dispose of assets, how to divide things up. And the community property regime makes things more complicated. There's certain things you can and cannot do. Everyone with me so far? Yep. Okay. The tenancy by the entirety, which is this sort of this type of estate we've been studying now for weeks, exists in common law states, New York, New Jersey, etc. It doesn't exist in community property states, but I'm hedging a bit because it kind of does, and I'll explain later why. But if you notice in California, we've had a couple of California cases, the couples that were married had joint tenancies. And the reason why is because I wasn't asking a question, I was about to pause, dramatic pause, but yes, you're right. Yeah. The reason why is it's a strange thing. The entire idea of a tenancy by the entirety is that they're separate, undivided shares, right? Separate but undivided shares. Dramatic pause, right? Separate but undivided shares. But in a community property state, there are no separate shares. Everything's together. So the entire idea of a tenancy by the entirety, or even a joint tenancy, is a weird fit in Texas. There are rules for this. We'll cover them next week. But when you're in a common law state, you can do that. You can have a joint tenancy for married couples. You have a tenancy by the entirety. Okay. Now, a lot of what we're discussing today involves debt. D-E-B-T, debt. Right? Why? Property law developed in large part to either make it easier for creditors to seize property or harder for creditors to seize property. Now, this is maybe an obvious point, but I want to just make it clear. If you owe a debt, right? Let's say you take out a loan, or maybe you have a gambling debt or a business debt or some sort, like you owe money. You have someone called a creditor, right? The creditors are someone who's owed money. And if you're a debtor and you don't pay the creditor, guess what? The creditor can come after your assets. He can seize your property to satisfy his debt. And this is a very important element of our society. If you cannot satisfy your debts, there'll be no credit. Right? Credit exists because they know if this person doesn't pay up, I can seize their car. I can seize their house. I can take their boat. Right? I can take their wages through garnishment. Right? There are many ways in which creditors can come first. You'll take a class later in law school called Secure Transactions. Probably will take that as a 2L, 3L. The entire point of secure transactions is who has priority, right? If someone doesn't pay a loan, who gets to go after their house first, right? Who gets to go after their car first, right? How do you prioritize yourself in this sort of hierarchy of debt? Okay. What becomes tricky though is it often a husband-wife law separate debts? If both a husband and wife take out a debt together, let's say they take out a mortgage, and they both sign it, that's marital debt. And it's not a problem, right? If there's marital debt, you can seize marital property to satisfy that debt. But what if a spouse has separate debt? For example, maybe the husband has a gambling debt, or maybe the wife got into a car accident and she owes a judgment for tort, right? When you have separate debts, it becomes a very difficult question. Can you seize marital assets to satisfy separate debts? And over history, we've had different answers, and we'll go through the different four groups in a few moments. But I want to explain why this exists. At common law, right, way back when the man controlled everything, the wife had no say. So if the husband had a debt, the creditors could reach whatever the husband had, because the husband had control over everything, right? If the husband had control over everything, the creditors could reach whatever the husband could control. In other words, the creditors could reach everything. So in the 1800s, states began giving women property rights. We have these laws called married women's property rights. Now, on face value, they seem like very much equalizing laws, right? That they gave women the right to own property. They gave women the right to have equal participation in the marital property. But not exactly, right? Prior to these laws, we had something called coverture, right? I spelled this wrong. Covertur. What's coverture? Coverture was literally cover, right? When the husband and wife got married, the husband literally covered the wife in protection, so to speak. The wife ceased to be a legal person. She had no control over anything. The wife and husband were regarded as one unit. Everything acquired during the marriage was basically belonged to the husband. All right? The husband had this right of possession. But as a consequence of that, whatever the husband controlled can be seized by the debtors. Seized by the creditors. The Married Women's Property Act changed that dynamic. These laws said that women now had control over their property. The first law to enact it, so the first state to enact it was Mississippi. Usually, you don't think back of Mississippi as being a particularly progressive place, but that's how it worked. Now, why did Mississippi do this? Again, it wasn't to raise women up. It's because there was a huge debt crisis, and people were losing their property to the banks. By giving women this sort of very small property right, it made it harder for the banks to seize marital property. Right? A wife could now refuse to sell property. Right? She couldn't manage it. She couldn't sell it on her own, but she at least had a say in whether the husband sold it. And that was sufficient to block the banks. That was sufficient to block the banks from seizing the marital property. So, again, it was a very progressive law in theory, at least, but it was designed primarily to help out debtors and keep the property in the home. A couple years later, for those curious, Texas, the Republic of Texas, enacted a Marital Women's Property Act, which was expansive in the state. Women could enter contracts, they could write a will, and sue for divorce. What? Yeah, historically, only the men could file for divorce. Outside of allegations of basically spousal abuse and battery, the women cannot file for a divorce. They cannot enter into a contract, even a will. You'll study, or me at least, in constitutional law, there's a case called Bradwell v. Illinois. This is a case about whether a woman can be an attorney. And one of the arguments against a married woman becoming an attorney was that married women couldn't form contracts. and an attorney must form a contract with a client. So the disability movement was sweeping. So at least in Texas, they allowed women to enter into contracts. They could write their own wills, that is, they could choose their heirs. Right? Imagine if you can't write a will, you're basically stuck with the intestacy statute. Whatever your children and husband, that's it. You can't basically write another will. Also, in the Texas law, women could veto the sale of property, and there's some other rights as well. So it was significant at the time. And throughout the 19th century, these various laws popped up in different states. But again, these were laws that were primarily not to help women. It was designed to protect creditors, debtors. All right. Questions so far? So today, just about every state has one of these marital property rights on the books. There are a couple outliers. We'll talk about them into the Hawaii case, but this is really the law of the land, really everywhere. Now, philosophical, and maybe people always get sort of agitated. Where's Alex? Courtney. All right, you next? You? Okay. All right, so go to 429, please. There's a problem in your book. I think it's 429. But the husband having a stroke. And if you just read that one, Alex, I'd appreciate it. Yes, please.
After having a stroke, H, anxious to avoid going into a nursing home or being cared for by professional nurses, entered into an agreement with W. H promised W that if W personally cared for him at home for the rest of his life, H would devise her certain property by will. In compliance with the agreement, W personally cared for H at home until his death. When he died, H devised the property promised W to his daughter by a prior marriage. Can W enforce the contract?
All right, what do you think, Alex?
If we're going based on the argument you gave from that common case, probably no.
Well, no, this is a modern case. This happens in the 1990s. This case came from.
I would say yes then.
Why?
Um,
Can a husband and wife contract for providing care and support?
would it depend on which type of system you're in?
Doesn't matter. It's California, but it doesn't really matter which one you're in.
I would say no. I feel like that's just like an inherent part of the marriage.
In sickness and health,
Yeah.
till death do you part. Amar, what do you think?
I think they could.
You could write this contract.
Yeah,
Why?
I think because it's not always true, just like in sickness and health and everything, you get divorced and it's not in sickness.
Yeah, but they didn't get divorced. They stuck together.
But I mean, you still contract, I'm sure. You can make a contract on anything.
Could you make a contract, Amar? And I always ask this one, not to get divorced. In other words, you tell your spouse if you file for divorce, there's going to be a breach, and you have to pay liquidated damages.
I don't think so.
Why not?
I mean, I'd say you could. That's possible.
But why couldn't you? Why would the law not recognize such a contract? Again, you tell your spouse, "I'm signing a contract with you. If you file for divorce against me, you can pay liquidated damages, $1 million, whatever the number is."
I don't think it's very like, fair and just.
But no, that's not a good answer, right? Why is marriage perhaps different that you can't use the usual rules of contract in like marriage? Why might it be different? Holden, what do you think? Why would the usual rules of contracting not govern marriage? I'll give you better. The Jackie Onassis clause, right? Well, I mean, you know what I'm talking about? There are actually some spouses and prenups that include sex as part of the prenup. That if it's not provided on a regular basis, it's voided. Can you enforce that contract? I'm 100% serious. Yeah, well.
Because like the marriage, they're supposed to be as one.
Yeah. So can you contract with yourself? You said twiggling yourself, I suppose, right? Shadi, is your hand up? Not anymore. All right. So what the court actually said here is that the contract was not enforceable. Right. The court said here the contract was not enforceable. Why? When you get married, you assume a duty of support, right? And you assume an obligation to support your spouse. This is not like having a roommate or something, right? That there's actually an obligation to support your spouse. The contract for the wife to receive compensation for doing legal duty was without consideration, right? This goes against public policy to even enforce this contract. And the court said, there's a dissent, by the way, we'll get to the dissent in a minute. The majority said to enforce the contract would degrade the wife, making her basically a paid servant in the home. And the husband had an equal duty to care for the wife. And this was antithetical to the institution of marriage. I'll get to this hand up.
Yeah, the idea of like an illusory promise or illusory contract.
Come on, what's illusory? I can't remember what that means. I'm sorry.
It's like a gift or a promise, or like it has the appearance of a contract.
No, it's unenforceable altogether. It goes against public policy. It's void contract altogether. Yeah, sorry, I hadn't thought illusory contract since like a long time ago. Trust me, that stuff just leaves your mind after a while. Yeah, Alex.
Wait, so did you say the majority said that the contract was unenforceable?
That's what the majority said. I'll get to the dissent in a minute. Brand?
So, I guess they're saying that they're contracting for the care, which isn't acceptable, but I feel like really they're contracting for the type of care. So,
tell me more.
She could have put him in a nursing home.
Stuck him in a home.
Right, or, continue to care for him inside of the house. So I don't think that they're contracting for her actually caring for him, because putting them in a nursing home would have provided care too. It's contracting for the type of care he's receiving.
That's the exact argument the dissent raised.
Oh.
Right, so yeah, dissent. Perfect. Right? The dissent, the wife could choose to pay for the care, stick him in a home, as they say, rather than providing it for herself. And the agreement to care was above and beyond what she was required to do. Right? This sort of penalizes the stay-at-home wife or the housewife, as they would call it back then. There's also a freedom of contract issue. But this, I always sort of bring up at this point to highlight, everyone shares the same conception of marriage, right? And suppose that evolves. This case was from the early 1990s, and maybe in the last 30 years, things have changed significantly now, but who cares, right? But at least historically, I think the majority opinion was what the majority rule would have been, that there's an obligation of support, independent, and you could not enforce a contract around it. It was a violation of public policy. So the question given more before, could you actually reach a contract that basically prohibits divorce or some sort of contract anticipation of divorce? The answer is no, right? Historically, that would violate public policy. The idea is we want marriage to stay together, and you cannot contract around what happens if you get divorced. You have a prenuptial agreement before the marriage, but you couldn't, like, say, if you divorce me or whatever, you get liquidated damage. I don't think that'd be an enforceable contract. Ryder?
So does that mean that a prenuptial agreement cannot be modified during the marriage?
You can, but they're very hard. Both spouses have to consent and probably be represented by separate counsel to make sure there's full knowing consent on that part, right? Because it's very easy for one spouse to say, oh yeah, I signed whatever, and they weren't represented separately. I mean, you could do a prenup with one lawyer. It's very risky. There's actually waivers of confidentiality because what might be in the interest of spouse number one probably won't be in the interest of spouse number two, right? It's sort of weird when you're a married couple. You can just put everything together unless you're talking about sort of marital arrangements because you don't have the same interests lined up. You might have your separate counsel. Yeah, did anyone do marital law? I think, is anyone involved with this at all? It's ugly. Divorces are ugly, especially with custody. It's ugly. It's not pretty. Did you guys take any marital property classes in your school?
Yeah, we have family law.
Is it community property system to France and Spain? Do you remember?
It's phased.
separate units.
Also, it's common law, for separate units. That's interesting. I didn't know that. Thank you for sharing. All right. All right. All right. So now let's talk about the tenancy by the entirety a bit more. The usual rule was that a tenancy by the entirety could not be reached by a creditor unless it was marital debt, right? If it was marital debt, you could reach it. But if it was separate debt, you could not. And that was one of the reasons why tenancies by the entirety were so significant. They shielded the homestead, right, the marital home from this creditor. Now you can title anything as you can title anything as tenancy by the entirety: a car, a boat, whatever you want, right? Even personal property. But generally, they were the homes. And one other thing. All right, one other concept. Then we'll go to Sawada, which is, I think, it's a fun case to talk about. Let's say you owe someone a debt, right? And you know they're going to come after you for your money. What happens if you transfer your money to a friend to hold on to for a couple years until the litigation finishes? And when they say, "Oh, look, he has no money, you can't collect anything," they drop the matter, and then your friend transfers money back to you. Can you do that, Margaret? Margaret?
No.
Why can you not do that?
Well, I think it's a type of fraud.
It is fraud. What's that phrase? Remember? When you convey something to try to avoid a creditor. What's it being called?
Fraudulent.
Exactly. Very good. Thank you. There's something in the law called a fraudulent conveyance. Right? Fraudulent conveyance. Right? A fraudulent conveyance. It's illegal to dispose of assets, get rid of assets for the point of avoiding a judgment, right? Basically make yourself judgment proof, right? It's illegal to basically temporarily transfer your assets to your son or your daughter or someone else to avoid a judgment. And you know what the courts can actually do if you engage in a fraudulent conveyance? They can cancel the conveyance, right? They can actually restore the property to its original owner so that it can be seized by a creditor. So, if you're, this happens actually a lot with divorce, right? Just trust me on this one. A couple is getting a divorce, and with a divorce, you have equitable distribution. You divide the money up roughly in half. One of the spouses will convey all their property to a friend, right? They'll sell their boat for $1, something stupid. So it's not mine anymore, it belongs to Joe. If the court finds that one spouse tried to fraudulently convey their assets to avoid the distribution, they basically cancel this, take it back from Joe, and they can chop the boat in half. I mean, proverbial speaking, they won't actually cut the boat in half, but they'll probably force the sale to give half the value of the boat. People do this all the time. They don't know how bad it is. They think, "Oh, I can, can pull a fast one on my spouse." There are records, and people figure this stuff out. The other one, and again, don't judge me, but it's true, is law firm partnerships. Right? Some of you will go through a law firm in a couple of years. If you become a partner law firm, it's a property asset. Yes, you have an ownership stake in the firm. You own X percentage of the firm, right? In Texas, at least, that's a marital asset. And if you get divorced as a law firm partner, you may actually need to sell your share in the firm to cover half of your spouse's distribution. So, and don't hate me, it's true. It's not uncommon for people to get divorced before they make partner, because there's a significant asset coming to them that would have to be distributed evenly. It's also not uncommon for people to try to shield their partnership assets before divorce to try to avoid dividing up. But anyway, so you'll find that people get very creative and malicious when they try to shield their assets. But that's background for the Sawada case. Okay. Questions so far? All right, Paige, let's do the facts, please, in Sawada.
Okay, the Sawadas were injured in a car accident caused by Mr. Indo. And Mr. Indo and Mrs. Indo owned property as tenancy by the entirety.
Good.
And before the trial, they conveyed their interest to their sons.
Oh, what were they trying to do, Paige?
They were trying to keep their property from getting taken
Yeah.
by the
Yeah.
Savalas.
They're trying to shield it, right? They're trying to shield their property. Now just to be clear, Paige, whose debt was this? Was this going to be the debt of the husband and wife as marital couple, or just the husband?
That's okay.
Because he was a tortfeasor, right? Okay, thanks so much, Paige. Right. So here we have the husband gets into a car accident and he injures another married couple. Guy has no insurance. And the only asset he has is the homestead, which is owned by tenancy by the entirety. Now, the husband's not an idiot, right? He knows what's going to happen. They're going to seize his house. He has this genius idea. He sells it to his kids. Is there any compensation paid that was paid for the house?
I don't think so.
No. Do the kids live there?
No.
Did the parents leave?
No.
Okay, so these are good kids, right? So I mean, if these are bad kids, they could expel their parents, right? Which didn't happen. But at least on face, this looks like a fraudulent conveyance, right? It looks like a conveyance designed to shield the asset from the debt, the creditors, in this case, who are the tort victims. Right? Because again, went to trial, they awarded damages, he had no money to pay it. They're going to go after the house. He did this. Okay, so the question becomes, was this conveyance fraudulent? Right? Was this conveyance fraudulent? And the answer is actually complex. And you see the courts go through a lot of analysis to get to the right answer, or get to an answer. Whether it's right or not, we can discuss it. Right? In order for this conveyance to be fraudulent, the creditors would have been able to seize it. Right? Let me say that again. In order for this conveyance to be fraudulent, this property could have been seized by the creditors. If it could have been seized by the creditors, it was a fraudulent conveyance. If the creditors could not seize Blackacre, it was not a fraudulent conveyance, right? It's only fraudulent if this was property that could have been seized by the creditors. So really the case turns to this question. Could the creditors have seized this property? The answer is yes, fraudulent. They cancel the sale, give it back to the husband, and then they could take it. The property could not have been seized. There was no fraud, and the Blackacre stays with the kids. All right. All right, so how do we then decide whether the creditors could have seized Blackacre, could have seized this property? All right. The answer turns on how we understand the Married Women's Property Act. Right? How do we understand the Married Women's Property Act? And at this point, Hawaii law was unclear, right? In Hawaii, it was unclear whether tenancy by the entirety could be used to satisfy the husband's personal debts. The trial court ruled for the husband and refused to set aside the conveyance. And then the Sawadas, they appealed. And then the Supreme Court of the state had to decide a question of first impression. Can the creditors seize Blackacre as a tenancy by the entirety? All right, everyone with me? All right, so Jaime, at common law, back in England in the olden days, right? What was the answer to this question? Could they seize it at common law? Okay, tell me why.
Couple was one, so they can take what that one had.
Well, the couple was one, but more importantly, who had the control? Okay. Did the wife have any control over the property? Okay. So Jaime, let me ask you this question, please. If there were debts that belonged only to the husband, Would the wife have any say over how that debt was handled? Okay, that's right. At common law, right, the husband had complete control. Right, the husband could even convey the property by himself. As a result of common law, the husband's personal creditors could seize the tenancy by the entirety to satisfy the husband's debt. The wife had no control over her marital property. She could not sell property on her own. The husband had what was called exclusive dominion and control. All right, kind of see this phrase over and over again. Exclusive dominion and control. So at common law, this was easy. Right? The husband was responsible for the house, therefore the creditors go after his debt. And it was this common law approach that the Marital Women's Property Act was trying to reject. Right? The Marital Women's Property Act was trying to reject this model of marital property. All right, so the court refers to this first group of states as group number 1. Right, group number 1. And group number 1 follows what might be called the common law approach. So Jacob, let me ask you this question. Look at question 2A on the board. And the facts are, like in this case, husband and wife are H and Y for husband and wife. They own Blackacre Cents by the entirety. H falls into debt. C asks the court to seize H's interest in Blackacre. In group number 1, could the creditor seize the tenancy by the entirety?
Yes.
Correct. Okay, why?
Because the property and the title of that property.
Correct. Okay. So in number 1, this is the old common law approach. And again, all this is in a common law state, right? This is why the word common law is almost deceiving, right? It's a common law rule in a common law state, or a common law rule in a common law marital property system. It's almost like redundant, but they have 2 different meanings. But the common law rule under group 1 means you could seize it. At least in 1977, when this case was decided, only 3 states followed the common law system. It was, Massachusetts, Michigan, and North Carolina, kind of random. They're sort of spread out. They're not anywhere close to each other. In all 3 states, a tenancy by the entirety could be used to satisfy the husband's debts. And this is group 1. Don't worry too much about group 1 because it doesn't exist anymore, right? Subsequently, all 3 of these states abandoned the common law rule. So it's basically a nullity, but at least you should know what the historical rule was. Okay. Then we get to group number 2. Lisa, what's going on in group number 2?
In group number 2, it's kind of like group number 1 where land could be seized, a property could be seized to satisfy her husband's separate debts, but it could also be seized to satisfy the wife's separate debts as well.
Ah. So how did the group number 2 states understand the Marital Women's Property Act?
I think they took into more of account of the Marital Women's Property Act, and so the wife has more to say, so it's not completely under control, but it's her interest could be alive, that's part of hers.
Very good. Right. So group number 2 was, again, it's kind of a weird hodgepodge of states. It was Alaska, Arkansas, New Jersey, New York, and Oregon. I mean, just scattered. This isn't like it's not a very strong grouping of why these states came together. At least New York and New Jersey makes sense, but the other ones I'm not sure. But these states basically said, look, women, if you want equality, you're gonna get your damn equality, right? No, that's exactly right. If you want to have equal control of the property, then your creditors can seize your share of that property. So, Lisa, what's the answer to question 2B? Could the court in group 2 seize the husband's interest? Yeah, it could. All right, but now we get to some sort of wrinkles, right? Zach, let me ask you this question. So let's say you're in New Jersey, right? And the husband and wife have a tenancy by the entirety. And the husband has some debts. And the creditor seizes the husband's interest in the tenancy by the entirety. How does that work? Does the wife get kicked out?
No, whoever is the one that's not in debt would retain the right of survivorship.
So basically the wife has a new roommate or something?
Essentially, you can't get out of it.
Okay. So basically, the husband doesn't have an interest in his own homestead. Now, is the creditor? Can the creditor evict the wife?
I don't think it fixed, but
What's he hoping happens?
she dies. That way you still get the fee simple.
Correct. Right. What happens if the wife dies first? Zach? What does the creditor have?
Then there's no right of survivorship, so you just take the property as a whole.
Right. If the wife dies first, the creditor owns Blackacre and fee simple. And do the other one, Zach. What happens if the husband dies first?
Creditor gets nothing.
Creditor gets nothing. Everyone see that, right? The survivorship right still kicks in. So it's this weird situation when you're the husband's interest in the tenancy by the entirety, you're hoping and praying the wife dies first. Because then you get Blackacre. If you don't, you get nothing. So it's actually still risky to try and go after a tenancy by the entirety. There's no guarantee you actually get anything valuable for it. It's kind of weird, right? Oh, right. I'm sorry. I didn't see your hand.
So right of survivorship cannot be financially transferred to another party.
Well,
Like,
in number two, right? In number two, the wife keeps survivorship right, right? That's fine. But the husband can lose his survivorship right. In other words, the creditors can seize whatever the husband has, his separate interest, and that separate interest includes survivorship rights.
Are they able, like, for example, let's say since I'm like, young, and there's right of survivorship held by creditors, can I buy right of survivorship with the hope that someone who's older than me will likely die before then and I take possession of their property?
It's a fun question. Yeah, you can buy anything you want, right? I mean, if you go to a creditor and you say, I'd like to buy that survivorship right, they can convey it to you. And you're a young dude, you can just wait out the wife. Yeah. I mean, look, these are not trivial things. I mean, imagine you're an elderly couple and you're not in the best health and you fall behind your bills. It's not an unreasonable investment to think, okay, we'll hold this for a couple of years and wait for the wife to die and we'll get it in fee simple. Right? It's sort of gruesome to think about, but it's not unreasonable. Right? Banks live forever, right? They don't have lifespans. Someone at the bank will eventually collect the survivorship right. Morbid, right? I know. All right, John. Let's talk about group number 3. What's group?
Group 3 is that the creditor basically can't go after the marital property at all. They're protected by the marriage.
Well, how does number 1 and number 3 differ? Right? Well, why does number 3 mean you can't go after anything?
Well, it's because it's just because you can't use the property to satisfy either one of the spouse's debts.
Why? What's the rationale for number 3?
The rationale is that they want to keep the home as one, and that they want to protect the home.
They want to protect the house.
Their property.
Okay, very good. All right. We often think of the tenancy by the entirety as not separate shares, but as a unity, right? They're there together. And in group number 3, they think these tenancy by the entireties are indivisible and inseparable. Creditors could not reach the land held by husband and wife. In fact, one court in Maryland said if you allow the creditor tenancy by the entirety, you're basically converting into a tenancy in common, which is basically what happens. This was my question to Zach a moment ago, right? If the creditor seizes the husband's interest, the wife has a new tenant in common. Right? She technically still has her survivorship rights, but she has a new guy in her property. So as a consequence of number 3, John, could you seize the husband's property? What's question number 2C? No, the answer here is no. That's correct. Now, this gives husbands some leeway, doesn't it, Frank? What does group number 3 like give husbands, or I guess wives as well, the free reign to do? Are they going to be worried about collecting their house, seizing their house? Yeah, it gives a blank check, right? If state, and let me read you the states. The list is actually somewhat long. District of Columbia, which is not a state. It's a funny story. I once did a filing in court, which involved a lawsuit brought by like 20 states in the District of Columbia, and I had a footnote saying no, DC is not a state. I like unimportant, right? Because they said like 23 states, and I was like 22 plus a. In DC and Delaware, Florida, Indiana, Maryland, Missouri, Pennsylvania, Rhode Island, Vermont, Virginia, Wyoming. That's group 3. These are all inseparable. So if you are a husband in one of those states with a debt, your homestead, your tenth by the entirety is untouchable. You can't come after it. Right? Now, Lexi, let me ask you a question, please. Let's say you're a bank in Maryland, one of these states, and the husband comes to you, so wants to seek a loan. What do you say? Do you give a husband a loan? What might you want to do to back up your claim? What might you want to do to back up your claim if the husband wants to come for a loan? And he has a tenancy by the entirety. What might you want to do? Oh yeah. Who has to sign the mortgage, sign the loan? The wife. And what happens? Joint. Correct. That's right. If it's a joint debt, that's both the husband and wife sign it, you can seize a tenancy by the entirety. Right? You can seize a tenancy by the entirety. So if you're a bank or some sort of creditor, you know the guy lives in Maryland or one of these other states in group 3, you make sure the wife signs it. That way you can go after the house. In New Jersey, it's not necessary because you can seize the husband's asset. You probably still make the wife sign it anyway. Right? But Chloe, that works for a bank, right? If you're giving a loan. What if you're a victim in a tort, right? Someone rams into your car. Can you check in advance how the property is titled before you get hit by a car? No. Why not? That sounds obvious, but why not?
You don't necessarily know you're gonna get
I hope we don't. Yeah, you know you're going to hit by a car. So banks perhaps be prudent and avoid giving a debt to a married person with the tenancy by the entirety. But if you're a tort victim, you can't like do a credit check on your tort fees before it happens. That doesn't. So again, in group number 3, the answer, Aaron. Oh no, Callie jumped over one. Group number 4 is kind of weird. There's only 2 states. What's group number 4? What's the rule there? Say that one more time, please. It made me remember, I think we're reading it. So just try to paraphrase your own words.
The spouse who's not in debt basically can't be penalized.
What can a creditor seize in group number 4? Correct. So this is actually the opposite of what Zach said a few minutes ago, right? In group number 4, you cannot seize the husband's debts, but you can seize the husband's survivorship rights. Isn't that weird? You can't seize the husband's interest in tenancy by the entirety but you can seize the husband's survivorship rights. All right, so now Aaron is up. Right, so imagine a husband and wife have a debt and they're in Kentucky, which is one of the two states. And Kentucky and Tennessee border, so this one makes some sense. Right? Can the court seize the husband's interest in Blackacre?
Yeah, they could seize his rights.
They can seize a survivorship right. Correct. What does it actually mean? What happens if the husband dies first? Does the bank ever get anything?
No, the wife would be left with fee simple.
The wife gets fee simple. If the husband dies first, the wife gets fee simple because of survivorship. What if the wife dies first?
Then they would have
Then who gets the bank if fee simple?
Yeah.
Yeah, I gave you the answer. Yeah, thank you, Aaron. Very good. Right. So basically, what happens here is the bank gets nothing so long as the wife is alive. But when the wife dies, the bank gets in fee simple. But the husband dies first, the bank gets nothing. So you're basically rolling a dice who's going to die first. It's very risky, right? Again, so even if you're in one of these states, number 4, you're probably going to want the wife to sign off on any debt. That works okay for a loan, but if it's a gambling debt or perhaps a medical bill or a credit card bill, the wife may not be on the bill or on the note, so to speak. Everyone with me so far? All right, Elizabeth, what does the Supreme Court of Hawaii do here? Which group do they favor?
They favor group
Why?
3, because they felt that the tenancy by the entirety was not subject to the individual, to the separate.
Why? Why? I mean, they had their menu, right? They're a common law court. They could pick whatever they wanted. Why did they pick number 3? Why didn't they pick 1 or 2 or 4?
Because they wanted to keep the land.
Oh, very good. That's right. And this is an important point, right? These are not federal courts, right? Federal courts are limited to what they can do. When you're a state Supreme Court, you can do what you want, right? You're the final word on state law. I mean, unless the legislature overrules you, they can do. And I think the state Supreme Court here relied on policy arguments, right? So one of the arguments that Elizabeth mentioned a moment ago is family, right? That this tenancy by the entirety should exist to protect the family. You had a husband and wife here. Actually, the wife died, but you had a married couple. They have kids. They should be able to rely on that property staying in their family. Another issue that may not be obvious to you, but in Hawaii, there was a huge issue at the time. Almost all the property was owned by several wealthy business owners. They were called the oligopoly. As a result, there was very few fee simple properties. The fact that this family actually owned their property in fee simple was significant. Indeed, you'll study in Property 2 a case called Hawaii Housing Authority versus Midkiff, MIDKAFF, Midkiff from 1984, Supreme Court case, U.S. Supreme Court case. And in that case, I'm not exaggerating, the government of Hawaii said, if you're leasing a property, you now have a chance to buy it from the owner. Basically converted all leaseholds to fee simple, and it forced the sale of property whether they wanted to or not through eminent domain. So basically, the government seized property from all the wealthy landowners. Serious. The court upheld it 9-0. I think it was maybe 8-1, but it was pretty lopsided. Right? So that's one policy argument, to favor land for the family and also to favor ownership in fee simple, not to chop it up into parts. Right? Because think about it, if the court ruled in favor of the victims in the tort case, the wife was already dead, so they've gotten in fee simple. You don't have to worry about the wife anymore, right? They've gotten 100% fee simple, the full bundle of sticks. The court also made an argument based on sort of policy that creditors can presume that if you have a married couple, you get both of them to sign the debt. But that argument doesn't really work with a tort, because again, there's no way for the victims of the car crash to know in advance that the only asset available was a marital property and tenancy by the entirety. Okay? Everybody with me? So in the end, the court held that the tenancy by the entirety is not subject to the claims of the creditors on one of the spouses during their joint lives. Therefore, the Sawadas could not reach the Endos tenancy by the entirety, and as a result, the Endos did not fraudulently convey Blackacre to their sons. Yes.
Could you go over what's the difference between group 2 and group 4?
Sure. With group 2, they can seize the husband's separate assets, including survivorship rights. In group 4, they can only seize the survivorship rights, not the present interest. So in other words, maybe say it a little differently. In group 2, you seize both the present and future interests of the husband. And in group 4, you only seize the husband's future interests. That helps, I don't know. All right. Yes, Shadi.
When they say like use some profit for either attached during coverage.
Yeah.
Does that mean they wouldn't be able to sell it? They can rent it out, use it, make money off it.
Correct. Right. So if the right, so if you're in a group 4 state and the bank has the survivorship right in the future, I think you're limited what you can do in a lifetime, right? You basically have to lease it out. But in other words, you basically have a life estate, think of it that way, right? Because once you die, it goes to someone else. People generally don't want to buy life estate property, so you're really limited what you can do on that. Yeah. Did it have? Stretch.
No, sorry.
Yes. Steve?
Do we need to know what happens if divorce in groups 2 and 4 since they
Right. So let me answer your question. With the divorce, that destroys the tenancy by the entirety, right? And that eliminates the survivorship right. So at that point, in group 4, that's a good question. I think the creditor would keep a survivorship right even if there's a divorce. I don't think you can get rid of that. That's his, not a keep. But in group 2, if there's actually a divorce afterwards, I don't think it matters. I think in other words, if you get divorced after the judgment's final, I think the bank never gets anything. Group 2. That makes sense? Yeah. I mean, once the judgment's final, group 2, the answer is no. Actually, hold on, I didn't look at this. So if you get divorced in group 2. Yeah, you know what? I think in group 2, if the bank ceases the husband's interest, and then there's a divorce, then the wife loses her survivorship rights, and then basically it's a tenancy in common. I think at that point, I think that's the right answer. Question. Yeah, divorce. Again, there are 2 situations we care about: death and divorce. The death rule is a little bit easier, but the divorce rules are messier because now you have a tenant in common. I think. What other questions on the majority? We'll get to the dissent in a minute. Preston, you next? Yeah. Preston, what did the dissent say?
They go with group 2.
Why?
They believe in equal rights between husband and wife.
And so, give me more. Tell me why is that significant?
So the bank can basically seize the husband's personal debts as well as the wife's personal debts.
Okay. But why? How is that equality if now you're taking away the wife's property for something she didn't do, right? She didn't assume the debt. Why is she being punished?
They said if she has control over her property, then she come with her equal disability.
Yeah, what's the phrase? You gotta take your lumps with the sugar, whatever that phrase is, right? You gotta take the good with the bad, right? If you actually want to be considered an equal partner in the marriage, you're not liable for the dumb stuff your spouse does, right? If your spouse assumes debts, you're not liable for it, right? And again, it may seem at first blush like, how can a wife be held liable for something she didn't consent to? But it does elevate equality because now, let's say the wife has a debt, right? Now the husband's on the hook for it, right? Each has their own separate interests. Right, so in the end, Hawaii goes with group number 3. The dissent would pick the New Jersey rule, group number 2. Right. So the majority said and going back to the actual thrust of the case, the majority said that the conveyance was not fraudulent. Why? Because the victims could never seize blackmail in the first place. The dissent said conveyance was fraudulent. Why? Because they could have seized it under group number 3. I'm sorry, group number 2. Group number 2 for the dissent. Okie doke. All right, questions on that case? It's a good case. I like it. All right, a few other notes, and I think we'll wrap up early. For whatever reason, I don't know why you guys finish early in the other class. I couldn't tell you. Like, the class always takes longer. I don't know if that's what was ever, but we always finish early class to the end. I couldn't tell you why, but I know you're not going to object. I don't know why. I've never actually counted. A few other notes. So even under state law, some states seize the tenancy by the entirety, other states won't. The feds, April 15th is coming up in 2 weeks, right? Taxes. I need to finish my. I'm slacking this year. I'm so busy. The IRS will reach debtor spouse in tenancy by the entirety. Doesn't care what state you live in. So if you're married and you owe money to the feds, to the IRS, all asset. Bankruptcy, which you'll take another class later in law school, perhaps. Generally, the tenancy by the entirety is considered protected. It's what's called a homestead, and generally the banks. I'm sorry, when you're in bankruptcy proceeding, your creditors will not seize your homestead. All right. I think that's about all I have. Let me wrap up. So the community property system is actually, the common law property system is actually fairly simple. With tenancy by the entirety, right? If you know what state you're in, you know how they're divided up. So just know your groups 1, 2, 3, and 4. Next week, we go to sort of a different question of what happens in the case of divorce, which is sort of what Christina was asking before. And what exactly is marital property? That's all I have. Any other questions? None? Enjoy. I'll see you guys later. Have a good weekend.